Hi, my name is Erik Fritz, and I'm an attorney with the Law Professionals. I specialize in bankruptcy, foreclosure, and commercial litigation. I'd like to take a brief moment this afternoon to talk to you about a really important 11th Circuit case that was recently decided in May. This decision is now binding precedent for bankruptcy courts in Florida, Georgia, and Alabama, the 11th Circuit. The case I'm talking about is In re McNeil, which says a Chapter 7 debtor can strip off an unsecured second mortgage in a Chapter 7 bankruptcy case. Okay, this all sounds like a lot of gobbledygook. So what does this mean, and why is this a big deal? Let's back up and start at the beginning. A lien is a security interest in property used to secure a debt, like a home mortgage, for instance. Here's an example. Suppose John owns a home that he purchased for $250,000, with 20%, or that's $50,000 down, leaving a principal balance of $200,000. The lender has a lien on his home in the amount of $200,000. At some point down the line, let's say John takes out a home equity loan, a second mortgage, of $70,000. This now creates a second lien on his home in the amount of $70,000. Now, like so many homes in Florida, this property is now underwater and worth only about $150,000 or so. So basically, John's upside down on the first mortgage, and he's completely underwater on the second mortgage. The first mortgage balance of $200,000 is considered partially secured, as it's secured by the current property value of $150,000. So that is to say, if the property sold for the current market value of $150,000, the lender would be out $50,000 on its loan. Additionally, the home equity loan, that second mortgage of the additional $70,000, is now a lien that is entirely unsecured, as there would be no proceeds to repay any of the $70,000 home equity loan if the home is sold for that $150,000 it's currently worth. So prior to the McNeil case, everyone believed that a Supreme Court case called Dusnup v. Tim said that an entirely unsecured lien, like the home equity loan in our example, could not be avoided or stripped off in a Chapter 7 bankruptcy. So if John had wanted to keep his home in a Chapter 7 bankruptcy, he had to keep both the first mortgage and the home equity line current, which doesn't provide much relief if he's having trouble making his monthly payments, because that's probably why he filed for bankruptcy in the first place. So the McNeil case, which just came down in May, says that a Chapter 7 debtor can strip off a second mortgage in a Chapter 7 case, so long as it's fully unsecured. So in our example, this means that if John qualifies for Chapter 7, he can now file for bankruptcy, strip off that second mortgage, that home equity loan, and be done with his case in about 6 months. So John would continue making the regular payments on the first mortgage, but he would no longer have to make any payments on that second mortgage, ever again. So call or email us for a free consultation to find out whether filing for bankruptcy may be right for you and your family.